Good evening, everyone. My name is Nityang Singhal. Today, I am going to discuss a very crucial topic of intellectual property law, which is labor theory, given by famous philosopher John Locke. Let's begin with the introduction. Why does law protect a book? Why does law protect a song? Why does law protect an invention? You can touch land, you can touch gold, but why can't you touch an idea? Why does the law protects the idea? Why does the law says this book is yours? Why does the law says this property belong to you? Why does the law says this is your idea and it belongs to you? Answer lies in one simple idea. Labor. Today we will understand the labor theory under intellectual property rights, not in a complicated philosophy but in a simple language. Because until you understand why IPR exists, you will never truly understand copyright or patents. Now we will look into the origin of labor theory. Labor theory comes from the philosophy of John Locke. Locke said something very powerful. Every human owns his body, every human owns his own labor. When a person mixes his labor with something, the result becomes his property. In simple words, if I work on something using my effort, that thing should belong to me. The idea was applied to land and physical objects, but later it was applied to intellectual creations. Now we will apply labor theory to IPR. Let's take an example to make it more clear. A forest belongs to no one, but if I cut the wood and make a chair, then the chair belongs to me. Why? Because I added my labor. Similarly, ideas are free, but when I write a book, it becomes mine because I write down my ideas, my emotion, my experiences in that book. For example, when a music writer writes a music, he writes his emotions, his ideas, his experiences, and whatever he feels. Every moment he lives, that he wrote down in his music. That's why the music becomes his own, because it's his own ideas. How labor theory justifies IPR. This is why law gives copyright to authors, patent to inventors, design right to designers, trademark to brand creators. Because law believes that labor deserves protection, labor deserves reward, labor deserves recognition. If people are not rewarded for their labor, then they will not write books, they will not make inventions, they will not make any contribution. So for further contributions, they are rewarded so that they will get some moral boost and confidence. Now we will look into the important limitations of labor theory. Now we will look into the important limitations of labor theory. Law does not protect raw ideas, facts, discoveries of nature, mathematical truth. Why? Because you did not create gravity, you did not create oxygen, you only discovered them. Labor theory protect original expressions, human creativity, intellectual effort. That is why you cannot copyright an idea, but you can copyright a novel. You can't patent a nature, you can patent a process. Let's move on to the criticism of labor theory. Labor theory is powerful, but it is not perfect. Criticism 1. Just because you work hard doesn't mean you deserve monopoly. Criticism 2. Sometimes value comes from society, not from an individual person. Criticism 3. Overprotection can harm public access to knowledge and culture. This is why modern IPR law balances creator rights and public interest. That is why IPR rights are time limited, restricted, subject to exceptions. Why labor theory still matters. Even today, the labor theory explains the moral foundation of IPR. Why piracy is wrong, why plagiarism is unethical, why copying without permission is illegal. You are stealing someone's time, you are stealing someone's labor, you are stealing someone's creativity. Now we will move to the conclusion. So remember, IPR is not about owning ideas, IPR is about respecting labor. Your mind is your factory, your creation is your product, and the law is the security guard. Labor doesn't only deserve wages, labor also deserves rights, even when it is intellectual. Protect creativity because without labor, there is no progress.